Hey folks, Dave Ceruolo, real estate, probate, and elder law attorney. In this video, we're going to talk about 3 ways that you can hold title to real estate with another person. In other words, concurrently. Now, if you're watching me on YouTube, make sure you hit the subscribe button below. If you're watching me on Facebook, make sure you like me. Stay tuned. So what is a joint tenancy? Well, a joint tenancy is a way that 2 or more people can hold title to a piece of real estate, and they're usually not married. So in this instance, you might have Joe and Sally, who are brother and sister, holding title to a piece of real estate. They both have 50% interest in the property. Joe dies, Sally gets Joe's interest by operation of law, and Sally holds 100% ownership in the property, no judge necessary. Now, what else with a joint tenancy? Well, in a joint tenancy, it's easily broken. So Joe can sign off on his 50% interest to somebody else, and then Sally will hold title with that new person. There will no longer be a joint tenancy, however, it'll be a tenancy in common. So in that instance, Joe sells his 50% interest to somebody else, Sally dies, it goes down her bloodline. There's no right of that is broken. So with the joint tenancy then, the parties aren't necessarily married and there's a right of survivorship which can be broken easily. Dave Ceruolo, CeruoloLaw.com. So what is a tenancy by the entirety? Well, a tenancy by the entirety is the way 2 people can hold a piece of real estate when they're married. And with a tenancy by the entirety, there's a right of survivorship. Just for simplicity's sake, you have a husband and a wife. The husband dies, there's a right of survivorship. The wife then is owner of 100% of the real estate by operational law, no judge necessary. What else with a tenancy by the entirety? Well, if the parties get divorced, the tenancy by the entirety is broken. If one dies, it goes down that person's bloodline. There's no more right of survivorship, so a tenancy in common is created when one dies. What else with a tenancy by the entirety? Well, you need both signatures on the deed in order to transfer a property out of a tenancy by the entirety. You just can't have one signature alone. The deed would be invalid. So with a tenancy by the entirety, the parties have to be married. You can only sever it with death, divorce, or agreement. Dave Ceruolo, CeruoloLaw.com. So what's a tenancy in common? Well, folks, a tenancy in common is a way that you can hold title to real estate. And what we say is a tenancy in common is actually a concurrent tenancy, which means that there's more than one person on title with you. Now, with a tenancy in common, the difference between this type of title ownership and the others is there's no right of survivorship. So you can hold title with your siblings, and if one of you passes away, that percentage of interest goes down that person's bloodline. And the loved ones or the family members of the person who passed away have to go to the probate court in order to receive their interest in the real estate. They have to get a judge's order, for instance, or the court's order in order to receive title properly. Now, can a tenancy in common exist when people are married? Well, yes, folks. As I just mentioned, you don't need to state a tenancy in common, so therefore, persons that are married can hold title as tenants in common with no right of survivorship. Dave Ceruolo, CeruoloLaw.com.